Thank you.
Thank you.
May it please
Mr.
the
Spear,
Court.
good morning.
I'm Brownlow Spear, and I represent Mr. Carlson in this matter. This is his appeal from conviction in the Essex Superior Court of first-degree murder by reason of extreme atrocity or cruelty. And with me is Mr. Carlson's trial counsel, my colleague, Attorney Lawrence McGuire. This case concerns the death of Mr. Carlson's girlfriend, Ms. Diane Ponessa, after having been beaten by Mr. Carlson in the living room of the apartment they shared in the town of Beverly. And the defense was not that Mr. Carlson was not guilty, but rather that he was guilty of manslaughter and not murder. Because, as the defense is, the absence or weakness of proof of any of the three prongs of malice, that is, intent to kill, to do grievous bodily harm, or to do an act which a reasonable person would know created a plain and strong likelihood of death. Now, we raise four issues, and I will address them in the order in which they are presented in our brief. Now, the first issue is the judge's allowance of repeated testimony that Mr. Carlson was not crying at the scene of the fatal incident in the presence of the victim's body when the paramedics and the police arrived on the scene. And this issue involves three separate rulings or sets of rulings by the trial judge. First, a paramedic was allowed to testify over defense counsel's objection as to his observations of Mr. Carlson's emotions, and his answer that Mr. Carlson wasn't crying was allowed to stand over another objection by defense counsel. Then, next, another paramedic, a second paramedic, was asked directly by the prosecutor, was Mr. Carlson crying at any point? And defense counsel's objection, again, is overruled, and the witness's answer was not that I observed. And then finally, the police officer was asked directly by the prosecutor, did you see Mr. Carlson cry at all while you were there? And again, an objection by defense counsel is overruled, and the officer answers, I don't remember seeing him cry, no. Now, the Commonwealth says it was entitled to present all this as demeanor evidence. I think that this went far beyond what is allowable as demeanor evidence. Testimony of this sort that supposedly shows a defendant's lack of remorse for a victim's death has been held inadmissible by this court. I've cited two cases directly on the point at page 29 of my brief. I think that rather than admissible probative evidence, what we have here is simply inflammatory matter of no probative value. The jury, in effect, were being invited to think of Mr. Carlson as a heartless monster. Now, the Commonwealth also says that this evidence was relevant on the question of the voluntariness of Mr. Carlson's statements and his Miranda waiver. And my response to this is that I suggest this is just an after-the-fact rationale devised to try to meet the defendant's claim of error in the admission of all this testimony. The testimony certainly wasn't offered at trial by the Commonwealth for any such purpose. Mr. Carlson wasn't given Miranda warnings until the following day.
What was the, when the defense counsel objected, what was the Commonwealth's response?
I don't believe there was any response. I think the transcript will show that the judge ruled immediately on the objections. There never was a sidebar conference held on this. These are all objections made in open court, and the rulings by the trial judge follow quite quickly, Your Honor.
So how can we conclude that that was an after-the-fact explanation if, in fact, had the Commonwealth been questioned? In other words, we don't know either way.
I suppose that is true.
Except that we know that the Miranda warnings weren't given until the next day.
Except that the Miranda warnings, of course, weren't given until the following day when Mr. Carlson is being taken into custody.
About voluntariness being argued about every statement he made in the aftermath of the murder, including statements made at the scene.
Well, certainly they're allowed to present evidence of what his general state of mind is. When voluntariness was an issue, yes, the jury was instructed on the humane practice that they had to weigh the voluntariness question, but I think it is just far afield to take the negative aspect of not crying, not showing remorse, and to say that that has any bearing at all on the issue of voluntariness. That would be my response to that, Your Honor.
Occasion, is it correct that this question about crime was inserted among a whole sort of litany of questions about observations of the defendant, his demeanor, his appearance, his behavior?
The first instance of it is not specifically called for, but it is volunteered in the paramedics' response to a question as to what his observations about Mr. Carlson's emotional state was. And that question itself draws an objection because it seems to be quite open-ended. And then the witness says, well, he wasn't crying. And I think at that point in the transcript, one can sort of figuratively see the light bulb appearing above the prosecutor's head. That sounds like great evidence painting Mr. Carlson as a very bad guy. And in the two other instances, the prosecutor specifically says, was he crying? Did you see him crying?
Was this mentioned in the DA's final argument?
No, it wasn't, Your Honor.
When we've said, and I think as you argue in your brief, we've said that the defendant's ambiguous movements and gestures are not admissible to show consciousness of guilt. But how is the fact that he did not cry or was not an emotional wreck ambiguous? I mean, aren't those just, we've said that hanging your head and things like that are not
hanging
admissible.
The head, biting the lip, staring
right,
at the floor.
things like that are not admissible. But, exactly. But if the fact that he is not crying, that's not ambiguous. I mean, he is not crying and he's not an emotional wreck.
Well, I would suggest that hanging the head, biting the lip, staring at the floor, these are all things that at least arguably could reflect something of the inner state of the person, but not crying is simply going from a negative to inviting very invidious judgments about Mr. Carlson's lack of remorse for the enormous damage that he has caused, and I suggest to really prejudice the jury against him. That's the reason that I led off with those cases, Your Honor, on the inadmissibility of these shows of emotion, because I don't think this shows anything at all. So we are contending this was error, and now was this prejudicial? I submit that it was, because this is actually a very close case as between murder and manslaughter. The evidence of malice is very tenuous. There's no direct evidence of any intent to kill, and there's no direct evidence of any intent to inflict grievous bodily harm, and there's no use of a per se deadly weapon from which a jury can be instructed that they can, if they wish, draw an inference of malice. The likely effect of this wasn't crying evidence is to lead the jury away from deciding the close question of the presence or absence of malice in the homicide of the defendant. And it's true, this wasn't stressed in oral argument, but it certainly is a repeated theme in the Commonwealth's evidence, and I think that at some point it would certainly have sunk in on the jury as to what they are being invited to conclude.
There is rarely direct evidence of intent, but surely the number and the nature of the blows being inflicted would support the inference of at least second intent to cause grievous bodily harm.
Well, by direct evidence, Your Honor, I meant if there was some statement by a defendant that, I think on the contrary, Your Honor, that there very often is such evidence, and that is used as direct evidence of the intent. And here, to say that we infer from the severity of the injuries, the state of mind of the defendant is really, I think, a kind of a circular method of imputing guilt. There is the fallback position of the third prong of malice. That is true, but I think that's for the jury to weigh, and I think it was a close question.
Didn't we have several witnesses who said they overheard the defendant talking to the victim over a period of time as he was
Yes.
inflicting the injuries? And wouldn't that, just the time frame, suggest that there was an intent to do serious injury to her? If they said it was 4 hours or however many?
Well, it could be taken as, I don't know if it was 4 hours. There was indeed such evidence, as Your Honor is recalling it. But again, this would be evidence that a jury could consider and weigh, but I think that their consideration of it is being prejudicially affected by the evidence that I've just recounted. If I could go to the second issue, which is the judge's allowance of testimony from a Mr. Canzano, a friend of Mr. Carlson, over repeated objection by defense counsel to the effect that Mr. Carlson charged the victim rent which was far in excess of her fair share of the rent, because Mr. Carlson had a housing subsidy which very substantially reduced the amount of rent he actually paid.
Was it rent? It was also for food, too, and
It was
utilities.
also for food, and the Commonwealth, in a footnote, points out that, well, maybe it wasn't that disproportionate, because we don't know how much the food cost. But, you know, that point was never brought up for the jury's consideration. I think what they were left with was that there was a huge overcharge of the victim for the rent by Mr. Carlson. The factor that it also included food didn't come into play, because of course it wouldn't reduce the overcharge by that much. What we're certainly left with is that there was some substantial overcharge of the rent, if this testimony is true, that he actually only paid, I think, $185 a month, and she had to fork over $500. Defense counsel objected to this. He objected to the entire line of questioning as lacking relevance. I don't see anything in the Commonwealth's brief that explains how this might be relevant. And what a contrast between this and the Commonwealth's struggle to get this evidence before the jury, which spans 4 pages, 157 to 161 at Volume 4 of the transcript. The Commonwealth simply says that this evidence isn't really inflammatory. Well, it's not as inflammatory as some other kinds of evidence, but it definitely does some harm to the defense in the eyes of the jury by painting the defendant as not a good person. And where the evidence is this close, as I submit, as to the existence of malice in the homicide, I don't think it can be said with fair assurance that it didn't tip the balance in the jury's minds, and that, of course, is the standard for preserved error.
As I understood the Commonwealth's brief, what they were arguing was that there was a financial relationship and a financial dependence that fed into the motive here, that he was angry at Ms. Conessa because she wasn't getting up to go to the bank and get him some money. And therefore the notion that he was looking to her for support, looking to her to support his drug habit, among other things, is in fact relevant.
Well, here there is a lengthy sidebar conference about the admissibility of this evidence, and I don't recall anything in the nature of financial dependence as being mentioned by the Commonwealth at that sidebar conference. And it goes on for several pages, so I'm not 100% certain of what the content of it is, but it's in those pages that I just cited. My immediate reaction is that this again is pasting together something to find some theory of admissibility, although I don't even think that that's specifically stated in the Commonwealth's brief. But I think the sidebar conference could tell whether or not this was in fact what the Commonwealth was intending to show by that or not. And my recollection of it is that it doesn't come up there. But like I say, I don't have it right in front of me. There was a separate objection by defense counsel to this evidence on the ground of hearsay, and the Commonwealth says, well, the proper objection would be a lack of foundation. And that may be so, but I think that the ground stated of hearsay amply alerts the trial judge to the fact that of this particular defect in the evidence, that its source is unknown and unreliable. It's probably technically not hearsay because we don't know who said it or what the source of the witness's information is. The Commonwealth faults defense counsel for not moving to strike Canzano's testimony after it was given, and I point out that before anything prejudicial was elicited, defense counsel stated his objection to the entire line of questioning on both the relevance and the hearsay grounds. I think that fully preserved Mr. Carlson's right to a review of the judge's ruling on the normal prejudicial error standard without the need for any subsequent motion to strike. The third issue is our claim of constitutional error in the judge's instruction to the jury in his final charge that they could consider evidence of other assaultive behavior by Mr. Carlson involving the victim, Ms. Ponessa, as determining his intent at the time of the crime. And the jury would readily have understood this from prior instructions by the judge during the trial to refer to the existence of malicious intent, which distinguishes murder from manslaughter. And what is erroneous here, we contend, is that the evidence of Mr. Carlson's prior assaultive behavior towards Ms. Ponessa doesn't come anywhere near the level of one of the malicious intents. I've cited and there's comment by the trial judge during one of the conferences on what instruction is to be given to the jury about the prior bad conduct, in which the trial judge analyzes it very precisely and in our opinion, quite correctly, but he doesn't adhere to that as the trial moves along. I've cited a Missouri case at page 43 of our brief that holds that the effect of such an instruction is to create for the jury a legally spurious presumption of guilt. And I think that case is very helpful in terms of illustrating just where it is that prejudice comes from an instruction of this nature. I'd also like to draw the Court's attention to its own decision in the case of Butler, 445 Mass 568, which was, that's a 2005 case, and the trial in this case was in 3 years before that, in 2002. It's cited at pages 39 and 40 of our brief, which seems to me to be supportive of the point I'm trying to make here, that the evidence which may be admissible in the trial judge's discretion, and of course here the defense tried strenuously to keep the evidence out, but the trial judge exercising discretion admitted it. I think the Butler case seems to make the point quite well that evidence which may be admissible for one or, this is prior misconduct evidence, that may be admissible for one or two or three of the permitted purposes, it may be error to instruct the jury that they can consider it also for other purposes for which it would be admissible if the evidence supported it, but when it doesn't.
If we agreed with you, we follow, as I understand your argument, we could only allow prior conduct on the issue of intent in a murder case where the issue is malice. If the prior incident involved, attempted murder or the infliction of serious bodily harm.
Well, I think that's a fair statement of our position. I think that is a fair statement of our position.
Have you said that before?
Well, I don't think it's been explicitly said. It is said in this Missouri case that I just cited. That's why it pops up in the brief. But I have collected cases at pages 40 and 41 in footnote 30, which show that the pattern of the use of this evidence in the prior decisions of this court in murder cases is that when the jury is instructed on an intent to kill, virtually invariably it's when the prior misconduct evidence is of a threat to kill or such a serious assault that one easily sees the potential malice in it. Now, the Commonwealth cites the Marshall case. The Marshall case is one in which the defendant held a knife to the future victim's neck. That's the prior misconduct. He also told someone that if care wasn't taken of his child, that the victim would get the same thing. This is very threatening, menacing behavior, and sure, it's admissible on the issue of intent to kill. But I've rounded up all these cases in footnote 30. In other cases where the prior misconduct doesn't rise to that level. As I see it, the jury has been instructed only as to motive, and those I have rounded up in footnote 32. So I think that's true, Your Honor. That is essentially what our position is here. Our last issue is an argument as to the need for jury unanimity on at least one of the Canine factors. This Court has rejected this argument several times before, and I respectfully request the Court to reconsider the issue. I'll rest on my brief. Thank you very much.
Thank you, Mr. Spear. Mr. Steinfeld?
Thank you. May it please the Court, Kenneth Steinfeld for the Commonwealth. I'd like to begin with the last point that Mr. Spear made, and that has to do with his theory that so-called lesser assaultive behavior is not admissible to show intent. I would submit that the DeMarco case decided by this Court in 2005, 444 Mass 678, is directly applicable and directly refutes that contention. In that case, there was evidence that the defendant belittled and berated his victim. He didn't like the way she did the laundry. He didn't like the way she did her makeup. He didn't like the way she cleaned the apartment, and he called her, he used slurs to refer to her. That evidence was admitted to show his intent that he murdered her, because it showed the nature of the relationship and the pattern of hostility and disrespect. So I think in that case, where there's not even any physical contact, that's admissible to show his intent. Then certainly in this case, when there was evidence of an actual beating, that is certainly admissible to show that he intended, that he had the requisite intent for first-degree murder. I'd like to go back to the first claim, the demeanor claim, the crying claim, and point out that, as Justice Sussman noted, the context of the questions makes absolutely clear the purpose both of the question and the response. If the Court looks on either side of those questions, there will be found similar questions
Mr. Steinfeld, I'm sorry. Could
Yes.
I just go back to the DeMarco case?
Yes, certainly.
At least I haven't read it recently, and I don't have it up on the bench. But at least according to the defendant, in that case there was evidence that the defendant forcefully held the victim's spouse's head under water in the swimming pool for 30 seconds. I mean, that's...
Yes. Yes, there was also prior bad act evidence that involved violence. What I'm saying is there was also prior bad act evidence that did not involve violence at all, and the Court did not distinguish between them and say the prior behavior that involves violence, that can go to intent, whereas the one that did not cannot. The fact, I think, in that case that there was both violent behavior and nonviolent behavior, and yet the judge instructed...
I understood you to be saying there was no evidence.
Oh, no, I'm sorry. No, I meant just to discuss the fact that there was actually evidence that of nonviolent prior behavior. But there certainly was a lot of prior assaultive behavior in that case as well, and I apologize if I left that misconception. The demeanor evidence, the questions all around it were clearly calculated to elicit evidence of the defendant's mental state, which was the only issue which was submitted to the jury, what was going on in his mind at the time. And because no one else was in that apartment, the only way for the jury to decide that issue was to hear evidence about what he was like soon afterwards. And all the questions were, did he appear relaxed? Did he appear calm? Was he able to speak? Was he coherent? And the prosecutor very carefully asked, I don't want your summary, your opinion, I just want your observations. And when first
But let me ask you, what would have been established if he had been crying? Well, what's to be deduced from that if he had been crying?
Right. The deduction from that would have been that he perhaps was in a frenzy before, that he was coming out of that. It would have been evidence that he did, in fact, lose control, as he claimed. That was his sole defense.
But wouldn't it have also been evidence of consciousness of guilt? If you're crying, you're essentially acknowledging the wrongfulness of what you did, the enormity of what you did. If you're not crying, you're impassive to what you did. You're in a no-win situation.
Certainly, but the parties in the court made absolutely clear to the jury what evidence was admissible for the purpose of demeanor and what evidence was admissible for the purpose of consciousness of guilt.
I have a question about that. Why would this evidence not be, the defense keeps arguing that it should not have been admitted as consciousness of guilt evidence. Why is that?
Well, we concede that it would not have been appropriate because grief response is a poor indicator of guilt or innocence. So the Commonwealth never attempted to introduce the fact that he did not cry and that he was not an emotional wreck to show consciousness of guilt. There were three types of evidence that the Commonwealth did seek to introduce for the purposes of consciousness of guilt. And the parties understood that, and the judge even instructed, during his instruction to the jury on consciousness of guilt, he laid out three types of evidence. None included demeanor evidence, none included the fact that he did not cry. And that also was included in the Commonwealth's request for jury instructions. When it sought a consciousness of guilt instruction, it laid out the three areas of evidence that it considered consciousness of guilt. The evidence that he did not cry and he was not an emotional wreck both went to the issue of his intent and to voluntariness, which, as the Court pointed out, was in fact a hotly litigated issue throughout trial. Judge Agnes...
Explain, you have to help me understand
Sure.
why it goes to the issue of voluntariness.
Pardon me?
Why it goes to the issue of voluntariness when the questions are sometime afterwards, right?
Because the Commonwealth was the Commonwealth was obligated to show that all of the defendant's statements, both to civilians and to police and to the medical technicians on the scene, were freely made of his own, made freely of his own will and the product of a rational intellect. There was a motion to suppress filed before trial, and Judge Agnes held extensive hearings and then issued a very, very detailed and thorough 40-page opinion.
So you're talking about the voluntariness of the statements made
Yes.
to observers at the time?
Yes.
Okay.
Yes, or that day and also the following day.
Sure.
Oh, I also wanted to mention on the issue of intent, there was, in fact, I think, very good direct evidence, although, of course, we cannot go inside the defendant's mind, but very good direct evidence of his intent to cause her death, to cause grievous bodily harm, or to undertake an action that a reasonable person would know would probably lead to death, and that is the fact that after he first started to assault her, he gave her a karate chop and he punched her, and then he stopped and went into his bedroom to change and put on his clothes, and specifically to put on his work boots. And then he came out with those work boots on and proceeded to kick and stomp her to death. And I think that speaks volumes as to his ability to have the intent that is required for first-degree murder and to refute the defense that he lost control. One who obviously loses control and cannot stop himself does not take a break to go on and put on boots to make the beating more savage and more effective. As to the prior bad acts, Justice Sossman has stolen much of my thunder. I would just like to point out that the fact that he derived $500 a month from the victim provides him with a disincentive not to kill her. It's actually quite favorable evidence to him because he needed money for drugs. There was testimony that he had a drug debt that he needed to pay. And if she were, in fact, providing him with income, which I don't concede because also, as Justice Sossman points out, that $500 may very well have approximated her share of the monthly expenses, he would need to keep that cash coming. And so for him to kill her would force him to lose that money, and it makes it more likely that he did, in fact, lose control. As to the violent prior assaultive behavior, as I've said...
Well, could I stop you on
Sure.
the amount of the money, which I don't see that the fact that he paid less than the full value of the apartment as rent, because he was on a rent subsidy. I don't see why that's something bad or unfavorable in any way, but assuming that it is, the individual who testified to that, Canzano, that might have been hearsay unless, it seems to me, unless the colloquy permitted the inference that Canzano learned from the defendant himself the true amount of his rent. Is that evidence in record that Canzano learned from the defendant himself the true amount of his rent and the information about the subsidy and the true amount of the rent?
There was evidence as to one that the defendant told him, but there was no evidence as to the other. and there was a hearsay objection. He didn't say the defendant told me that he only paid $185. But as I said in my brief, the proper objection was foundation, and had that objection been made, it seems highly likely from the fact that the witness was a childhood friend of the defendant and he considered him a brother, he would have said the defendant told me. And that certainly would have been admissible as a statement of the defendant. So the fact that the statement probably was based on a hearsay statement did not prejudice the defendant at all, because there was evidence of this lifelong relationship between them. And also, Mr. Canzano was the person who put the rental agreement together. His girlfriend typed it that said that she would pay him $500 a month for rent, food, and utilities. So he was intimately familiar with the lease arrangements or the financial arrangement between the defendant and the victim. And I think that it's a clear inference that the jury could have found that he knew exactly how much the defendant actually paid and what his rent actually was. As to the other issues in my brief, unless the members of the panel have any questions, I would like to rest on my brief.
Thank you, Mr. Stein.
Thank you very much.
We'll take a short break.